This episode of the Police One podcast is sponsored by Officer Store. Learn more about getting the gear you need at prices you can afford by visiting officerstore.com. Courtesy of Officer Store, listeners receive 10% off now through December 31st using the promo code POLICE1. That's police and the number 1. Hey, welcome back. You are listening to Policing Matters on policeone.com. I'm your host, Jim Dudley. Hey, check us out on our YouTube channel as well, and you can get a look at me and our guest. Well, the United States Supreme Court made some significant rulings on cases this year that affected policing in America. Still, some important issues await, and some may be resolved before the end of the year. But today, I have Terry Dwyer. Terry Dwyer retired from the New York State Police after a 22-year career as a trooper and investigator. He is now a tenured professor in the Justice and Law Administration Department at Western Connecticut State University and an attorney in private practice representing law enforcement officers in disciplinary cases, critical incidents, and employment matters. He is the author of the soon-to-be-released Homeland Security Law, Issues and Analysis from Congela Publishing. Well, welcome to Policing Matters, Terry Dwyer.
Thank you. Please call me Terry.
Well, Terry retired from New York State Police as an investigator, a trooper, professor, attorney. You've got all sides of the issues, and you've done some great reviews, annual reviews on Supreme Court cases. You've got an article coming out in policeone.com, just like last year. Well, one case in particular this year decided the difference between stalking and our First Amendment rights. Such was the case in Counterman versus Colorado. Tell us about it, and what does it mean for online threats, bullying, and so on?
Well, it's an interesting case, and I think it's of limited application, but it's something for police officers to be aware of. There's a local singer in Colorado, and she was stalked by an individual unknown to her who sent her various messages through Facebook and other online media, I believe. And some of them were very benign, like "Good morning, beautiful. How are you today?" And then others were more direct nature, some cursing involved, some underlying threats. She contacted the police. The police responded. They did their investigation, and the individual was arrested. The problem with the case, by the time it got to the U.S. Supreme Court, was that there was no subjective showing. The state statute only required just basics, that there's a threat and there's a fear on the behalf of the victim. There was no, that's an objective standard, what the court said. There's no subjective standard. We all know as police officers, you need the act, the physical act for a crime, and then you need the corresponding mens rea, the mental element. And what the court said in this instance was that there was no subjective element. There's no mens rea being shown. Justice Elena Kagan wrote the decision, and she said, look, all we need is the bare standard of a recklessness, at least, to show. And all the prosecution offered, and this is by no means a failure on the police part, that this is just what the statute required at the time, but the prosecution only had the messages that were sent. And absent showing some indicia or indicators of the subjective state, that the individual knew or was likely to know that his messages would cause annoyance and alarm, there was basically a failure in the proof. So the U.S. Supreme Court said that there are things known as true threats. Basically, it's intimidation and likely to cause some sort of annoyance, alarm, concern. But there's always, in crime, unless it's a strict liability offense, such as speeding, you have to show a corresponding mental state. And that's essentially what the court said here in Counterman. I thought it was an interesting case for police officers, though, because how many times are officers called to harassment or stalking complaints? And we know history tells us that some of them may be fairly innocuous, but many lead to more serious events, or could potentially. I think it's just kind of a caveat for officers to be aware that, aside from taking the statement from the victim, there's more. I don't believe there is an interview, and I could be wrong, but I don't recall there was an interview of the defendant in this case. And so it's just like that extra step that officers need to take in these sort of cases, because the court has said, look, we have to be careful around speech, and police always have to be careful. And in this day and age with social media, protests, not that we haven't had them in the past, but we have social media. We have the ability. Everybody's a news reporter now. Things get posted immediately. Officers have to be aware when they are arresting individuals on anything relating to speech or conduct. The court has said we can place reasonable time, place, and manner restrictions on speech, and certainly a true threat. We can statutorily limit true threats. That's a reasonable manner restriction on speech. So while police can arrest for that, our officers have to be sure that they have that subjective element, that they can prove or bring to the prosecution that mens rea element.
Yeah, and this puts cops in a difficult position because, like you said, we're often called to these kinds of threats, sometimes domestic violence, but sometimes between strangers, otherwise strangers, in these stalking situations. So maybe what it really means is that police officers who take these reports have to be very nuanced in how they portray what is told to them by the victim. And sometimes, like I say, it's nuanced. There may be facial gestures or hand gestures or a veiled joke when we know it's really a threat. And that's really got to be articulated in the initial report.
Yeah, absolutely. I mean, the victim, and look, if the victim is going to express some sort of fear or concern, or that they're intimidated, that's fine. What the court is saying is that we need some sort of proof of that mental element on the part of the perpetrator, the defendant. And again, that could be as simple as often is done in these cases, going to the source of the threat and determining the nature of it. And an interview could certainly, meet that criteria. What is told to the police officer. And again, in this case, it's not so much an infirmity on the part of the police officers. It's the state statute, and it's what was required under the state statute. So the statute itself was not thorough enough or not clear enough. And that may be something that the legislature may go back and look at. But again, an interesting case and just something for officers around the country to be aware of. We speak broadly when we talk about Supreme Court cases, but as I always warn in any of my articles, this is the general rule that the court puts out. States, under their separate constitutions, can certainly provide broader constitutional protections, and we have to look at the state statutory law as well if we're dealing with a state issue as opposed to federal statutory law.
Yeah, absolutely. And so something more common that a police officer may encounter are, of course, Fourth Amendment searches and seizures. Pennington versus West Virginia. It's a case that talks about whether or not police can lawfully enter a home to search for a subject of an arrest warrant. Tell us about that one.
Yeah, well, actually, this was kind of a year where there was not a lot going on. Normally, I have a slew of cases when I'm doing my year-end review that deal with the Fourth Amendment or Fifth Amendment. Lately, a lot of qualified immunity cases. And I have an upcoming article for Police One that, again, gives my year-end review, but it's not so much about what happened as far as what didn't happen. Pennington is the case that the court refused to grant review of. And it involves Peyton versus New York and a split amongst the different circuits, the federal circuits. Generally, when there's a split amongst the Federal Circuit Court of Appeals, the Supreme Court will take a case to consolidate that. They did that many years ago in the case versus Wren versus the United States. Dealt with issues of racial profiling, whether a subjective versus objective standard applied. And there had been a split in the circuit. Among the circuit courts, and the court consolidated that. They didn't do that here, and that's what the attorney for the woman who was arrested sought. So with Peyton versus New York, we know that the court has said that if police have a reasonable belief that a person might be in a location and they have an arrest warrant for that person, they can proceed to enter. They don't need a search warrant if it's that person's location. And the language is reasonable belief. Now, how is that language interpreted? Some circuits, like the Second Circuit, where I'm in New York, say that it requires less than probable cause. It's a less stringent standard than probable cause, and the D.C. Circuit follows suit, and I believe the 10th Circuit. I have it here in my notes. Yes, the 10th Circuit, but other circuits, the Third, Fourth, and Sixth Circuit, take a view that reasonable belief equates to probable cause. And in this case, it was a young girl. There was basically a truancy petition out for her, which is equivalent to a warrant in that location. And they believed that she was in the house. Now, they didn't have permission to enter. They didn't have a search warrant, but they went in under the basis of that truancy warrant. And they ended up arresting the mother for concealing a child. The court denied review on that. They simply denied review, and they didn't take the case to look at what the attorney was seeking, the appellate attorney, to kind of consolidate the issue. So I just thought that was kind of an interesting case that they bypassed. And again, officers just have to look to the state statutes and what their prevailing state law requires in that sort of situation. I think this was unique in that it seems like the state law again equated the truancy warrant or petition with an arrest warrant for the child to bring her back to school.
Yeah, and we've seen that before here in San Francisco. We had cases where there was a administrative warrant issued to health inspectors, and our role as law enforcement officers going into the property was a little bit different, just like you're talking about, that it's not a search warrant and it's not an arrest warrant. It was an administrative warrant for health officers to investigate. And that was where I think it was the Ninth Circuit Court here in California drew the line.
Right. Yeah, exactly. And that was one of 4 cases that the court essentially denied review on this year. That normally, if they granted review and issued a decision, I'd be talking about those cases in my article. And another case that they denied review on was Lombardo versus City of St. Louis, and this was a case that the court decided in 2021, and it was a case dealing specifically with issues of qualified immunity. And in that case, the court sent it back down. They said, I believe it was the Eighth Circuit. Yeah, the Eighth Circuit improperly inserted themselves in the place of the jury when they determined that the actions of the officers, and this involved somebody who was in a cell, I believe who was unruly. The officers got the individual prone in the cell. There were several officers involved, and they were kneeling on his back for some period of time. The Eighth Circuit, held for the officers. Supreme Court gets the case. They reviewed it. They said they really didn't look at the full picture. They kind of acted too hastily. They sent it back down with their directions for review. When it went back down to the Eighth Circuit for review, following the Supreme Court guidelines, the Eighth Circuit once again ruled in favor of the police officers. The parents of the individual who was injured, I believe died, again sought review in the U.S. Supreme Court to review now the Eighth Circuit's determination that there was in fact qualified immunity that it applied, and the court here now refused to grant review. So the Eighth Circuit decision, after it was sent down, stayed as it was. So again, this is a case in 2021 that the court issued a decision in, bounced back up this past term, and they denied review.
Yeah, so that was Lombardo versus the City of St. Louis. And
yes,
in our current era of elected district attorneys, or sometimes state attorneys, they seem to be pushing the boundaries a little bit in prosecution of police officers. I have to believe that in some cases they know they're not going to make a win, but maybe just the charging is there for the sake of appearances for, segments of the community that elected them to, quote, clean up policing. Is there any recourse for those kinds of cases? Can a city attorney, a district attorney, or a state attorney, is there any recourse against them for these sort of malicious, I don't know if we could call them malicious prosecutions?
District attorneys, prosecutors have absolute immunity for decisions that they make. But if I can take you back in time to the Duke lacrosse case, and if you're familiar with the circumstances there, the district attorney there, and this didn't involve police officers, but involved several collegiate lacrosse players and accusations of rape against them. One of them wasn't even at the scene, and thankfully he had an ATM receipt and I believe video to confirm that. But the prosecutor, Mike Nightfong, was subsequently prosecuted for his conduct in that case, his egregious conduct, holding back evidence, and everything else. That's an extreme example. If a district attorney is acting on good faith, an individual, a police officer, is going to be hard pressed to seek any damages or relief. I do believe there have been some cases filed in the country. I want to say possibly in Philadelphia. I don't know, maybe somewhere else. I do recall reading something in the past. I don't have the full facts regarding it, but there has been some pushback. Sure, officers have sought to push back, and they've obtained counsel to do so. I would submit this: the circumstances have to be fairly egregious on the part of any prosecutor because of the immunity that they're permitted under our law. But there has been some movement. Yes, there certainly has been.
Yeah, I'd love to see it. I know I can think of one case in particular where I think there was a strategy where the district attorney used a grand jury to indict command level officers, and based on perjured testimony and false facts brought into evidence. And of course, there's not much of a defense, no defense in a grand jury. And they did indict, but after the smoke cleared, the officers were acquitted, and the original charged command people were given a decision of factual innocent by another judge reviewing the case. So you would think in those terms that there would be some sort of recourse. We'll keep watching on that.
Sure. I mean, look, there is such a thing as prosecutorial overreach, and there is such a thing as prosecutorial misconduct. I had a professor in law school who was one of the foremost experts in prosecutorial misconduct in the country, and wrote a book on it and several law review articles. So yeah, it's definitely possible, and it's out there. And look, I think any working police officer has no problem if a fellow officer does something, commits a crime, or acts in an egregious manner outside of their sworn oath, would have no problem. The issue is the overreach in a lot of cases, and it's always going to involve use of force. It has involved use of force. And there are clear-cut examples where we could look at and see some videos and say, sure, that's potentially actionable, and the officer has some issues. There are other cases where, the Supreme Court has consistently said, in terms of qualified immunity, we're not going to subject split-second actions on the street to kind of 2020 hindsight. So that's the other factor that comes in. And something that I've always talked about in anytime I've given use of force presentations, depending where you are in the country, you have to be concerned or aware of the concept of officer created jeopardy. Some circuits, some federal circuits, in terms of qualified immunity issues and use of force, will look at whether or not the officer put themselves in a position that created the jeopardy. And if that's the case, that will negate, for lack of a better word, any qualified immunity claim or objective reasonableness claim. So that's something else that officers need to be aware of, and also the finite differences between, qualified immunity jurisprudence and Fourth Amendment use of force jurisprudence. I know there's been some presentations. There's two that I've seen recently around the country with attorneys doing some presentations on kind of the subtle differences. And these are police attorneys. These are individuals who've represented officers for many, many years and are familiar with the landscape. All too often, what I found in the past is that municipalities don't have separate dedicated police attorneys. They have the municipal attorney, the town attorney, the village attorney, quite good in what they do. But these are individuals who largely handle contracts, land zoning issues, and are called in when something happens involving their municipal agency. And they're not schooled or aware in the various issues, the multitudinous issues involving police officers and use of force and qualified immunity and everything else. So there's a lot of education out there, and there's a lot more that we need to get our officers.
Yeah, let me ask you a little bit more about qualified immunity and one case in particular. But first, I'd like to take a moment and thank our sponsor, Officer Store, equipping protectors with passion. That's how we operate, and it's how we live. We understand that having the right gear can mean the difference between life and death. Our goal is to get you the gear you need, when you need it, at prices you can afford. Visit us at officerstore.com. And we're back, and I'm speaking with Terry Dwyer, retired New York State Police Trooper, investigator, professor, and attorney. We're just touched on qualified immunity, and after the George Floyd incident and Breonna Taylor and a couple of others, qualified immunity became a hot issue, maybe a moral panic issue around the country. It was portrayed as a, do all, be all shield for police officers. We know it's not. It doesn't shield police officers from the kind of malice and egregiousness that they were accused of in the attacks on qualified immunity. In Fox versus Campbell, the issue is a critical one in that it relates to qualified immunity for police officers. What did the Supreme Court say on Fox versus Campbell?
Well, again, this is another case where the court denied certiorari. They didn't review it. This is a case out of the Sixth Circuit. And in this case, two deputies went to a home on a welfare check. And the individual at the residence, there's an individual and his spouse or significant other in there, didn't initially respond. There was some back and forth through the door. When he did respond, he asked the police if they had a gun. They asked him if he had a gun. He said he did. It ended up he didn't. But within 28 seconds of arrival, one of the deputies fired 2 shots at the door. And then at the 31-second mark, there was another 6 shots that were fired. So 8 shots within the span of 31 seconds. The court denied review. What happened in the lower Sixth Circuit Court of Appeals, it was a lengthy decision. I didn't get to read all of it, but I read the highlights. The court, a summary judgment motion was brought by the officers to say, look, there's no issues of fact here. There's issues of law, and the law should favor us. The court partially granted their summary judgment motion and partially sustained the complaint. What the court did is it left in the excessive use of force issue and whether or not there was a seizure, whether at the time the police officers fired, the individuals in the home were effectively seized under the Fourth Amendment and could not willingly leave. And then again, the issue whether or not it was an excessive use of force. The Supreme Court denied review on this. They let stand the Sixth Circuit decision, and the case was sent back down. So I think you touched on it in the lead up. Qualified immunity is misunderstood in a lot of sectors. It's misunderstood in the sector that screams for the end of qualified immunity. And it's often misunderstood in the law enforcement sector as well. It's not a be all and end all shield, cloak of armor that's going to protect officers. But it is fairly extensive, as Justice Byron White said many years ago in Malley versus Briggs. Qualified immunity protects all but the plainly incompetent and stupid. So again, we're talking about egregious conduct, and we get into the difference when we get to qualified immunity issues is whether or not the law was clearly established, right? And that's the crux of it when courts are reviewing instances of qualified immunity. If the law is clearly established and the officers violate that law, then certainly there's going to be constitutional liability. What we saw in post George Floyd is a lot of states moved to initiating their own kind of anti-qualified immunity laws that under our state laws, they can't change what the federal courts have said. They can't change what the U.S. Supreme Court said regarding qualified immunity. What they can do is under state statutes, limited as a defense. This is something that for years I've always marveled at, because I've always marveled at plaintiffs' attorneys that are suing police officers running right away to the federal courts and getting on their horses, charging on their steeds, and constitutional violations. And the court has made those cases increasingly hard to sustain against officers. Again, the conduct has to be fairly severe. But I always wondered why they didn't bring state law claims. Why did they bring state law claims, which I thought would be an easier road path for them to go? Now, if those state road claims are brought, a lot of states have ended that kind of qualified immunity at their level. They say we're not going to permit it. And again, it's not a broad stroke. You have to look at the state statutes, but that's essentially the environment we're in today.
Yeah. And again, when we talk about things like search and seizure and things that are open to plain view, we use technology more frequently. We have automated license plate readers, video systems, drones. We're even tapping into, community members, Ring and other devices. How did Moore versus the United States affect the use of cameras in public places?
Yeah, well, again, it's not a Supreme Court decision. It's one where they denied certiorari, they denied review. But again, it's interesting to see what cases the Supreme Court is going to take and which ones they're going to turn down. And certainly technology has been an issue. And this is a case that I was interested in because when I was an investigator, I had an informant. I had a case I was working. I had a Middle Eastern CI. I was looking at a lot of things that subsequently after 9/11 were like, whoa, this case is bigger than I originally thought. And I had a pole camera outside a mosque on a public utility pole. Our tech unit put it up, and I was watching that location because my informant had told me certain things, and I knew there were certain targets going in and out of there. And it was a certain date and time I would set it up. That was 2001, 2002. What the court did in Moore versus the United States when it refused to review that case was a case out of Springfield, Massachusetts, and federal agents had set up, same thing, a pole type surveillance camera. And it was an 8-month surveillance. Now, the technology is far more advanced than what I was using in 2001, 2002, but I was happy with that technology back then because it was a lot better than the old Nagras we used down in New York City. Those hot packs that you used to put on an informant or an undercover. But there's a lot of information that you can find out with a pole camera and the ability to pan, tilt, zoom in. So they got a lot of personal information, plates, packages that they were carrying in and out of the location. The court again refused to look at the issue and just kind of let the lower court decision stand, and the First Circuit decision, which said you know what? It's not a search. It doesn't violate the Fourth Amendment reasonableness clause. Now, there had been a prior case, United States versus Tuggle, out of the Seventh Circuit, that really dealt with the same issue, except this surveillance was for 18 months. It's an 18-month long surveillance. And I have to go back to the Carpenter case. The Carpenter case came out of the court a few years before, and that involved the cell site locator information and whether police need a warrant or not. It used to be that police would just go to the providers, the communications providers, and drop a subpoena and get information. And we all know our cell phones are tracking us daily. And the court said there's this thing called the mosaic theory. Little parts, pieces may add up to create this mosaic, and thus requiring Fourth Amendment protection, privacy protection. What the lower court, I should say, in Moore and Tuggle, they said, well, the poll camera doesn't rise to that level. It's not so intrusive that we're going to say that the police need a warrant to do so. This is right now, that's good for law enforcement. It's very good for law enforcement, but I could foresee this issue coming back to the court. I could see them eventually maybe getting that right case and reviewing this issue again. I would hope that they would let the law stand because it is in a public place. There's no reasonable expectation of privacy in public. But it depends on the facts of each individual case and how an appellate attorney is going to craft it. You know, what's done at the trial level and how the case develops. I mean, facts, little facts really make the difference in many cases with Fourth Amendment issues and searches and seizures. So that's an interesting case. I'm curious as to see what might happen in the future.
Yeah, and I mean, sometimes we get out technology before we get out policy, or the courts make a decision. And I mean, we're talking about the Supreme Court weighing in on cases, but in most of the cases we're talking about, they refuse to see them or review them. And I think that in itself speaks volumes, doesn't it?
Oh, absolutely. And look, the law is always catching up with technology. I mean, many years ago, Justice Brandeis wrote an article, "The Right to Privacy," and it was before he was even a judge, and he's an attorney. And when it was in the Harvard Law Review, and he was talking about the advance of new technology, and basically the new technology that concerned him was the camera. You know, the camera had been around for a while, but you know, he was talking about that. So sure, and you know, the U.S. Supreme Court hasn't had a case directly on drone usage. A lot of lower courts have. The precedent to be guided by for drones is basically cases go back to the 80s from the U.S. Supreme Court. We haven't had a case directly on point on drone usage. We probably will at some point in time. I could also see some issues involving this mosaic theory coming up with that as well, because I mean, drones, the capability and capacity and what they can do, and you can be in navigable airspace, and which is basically the criteria, and zoom in and just collect data 24/7 on a location, on a residence, even one that's secreted in the woods. And then there have been some lower court cases, circuit courts, state court cases that have dealt with this issue. And they're interesting cases, certainly. And again, they revert back, some of them, to the 1980s holdings, 1990s too, of the U.S. Supreme Court, dealing with fixed wing aircraft and helicopters and things of that nature.
Yeah. Yeah. And speaking of technology, and I got to say this, that local jurisdictions often attack the use of ShotSpotter, which is a listening device that are put on polls, and also talk about privacy issues. But I mean, you just said it, that in public, there should be no expectation of privacy, but we'll see, at least in local jurisdictions, you know, communities and anti-police tactics people going after the use of technology to help.
Well, and yeah, just to clarify on that too, I mean, in public, there's no reasonable expectation of privacy, but you know, I always ask my students, you know, do you have a right to where you are, kind of locational privacy? Who knows you're here other than your classmates or your parents? And they talk about them being tracked by their phones. Under this mosaic theory, again, if the government surveillance is so intrusive, and that's what Justice Rehnquist talked about many years ago. There were two cases, United States versus Caro and United States versus Knotts. And I believe it was in Knotts where he said, look, if we get to the point somewhere down the line where it's that dragnet type law enforcement, then we may have to revisit this issue. Well, I'll submit we're there now. We do have that capability for dragnet type law enforcement through all of the technology we have. It's a question of how invasive it becomes to that individual or in our individual lives. The third party doctrine, Justice Sotomayor has been pushing to maybe get rid of the third party doctrine, or limit it, because their cell phones nowadays are so ubiquitous. Everybody has one, but who reads their end user agreement? And there was a recent case, and the name just escapes me right now, but that was an issue in that as well. So, yeah, the law is always behind in technology and seems to drag its feet a little bit too. But the court waits for that right case to come before, because they look at issues very narrowly, very fine line that they're going to look at issues.
Yeah. Well, we've had for, probably decades now, the ability to put together kit guns, maybe replica guns, World War II, Civil War replications. Now we're talking about ghost guns. Has there been any case looked at or decided by the Supreme Court yet for ghost guns or guns made on 3D printers?
Again, not directly. The court denied. The court basically, I believe it's got the Fifth Circuit, upheld. I'm sorry, let me go back. They supported the government. They supported the government in the ATF's ban on ghost guns. The courts in Texas, the district court there, has been pretty active with pushing the agenda of ghost guns and favoring them and putting an injunction upon the ATF guidelines. The court basically listened to an emergency order review and lifted the ban. The court hasn't spoken on it one way or the other in any substantive matter, but they've just said, hey, the prevailing policy under the Alcohol, Tobacco, and Firearms is going to stand. This is an issue, though, I'm sure, again, is going to come back to the court. And those cases, I have them right here. It's Garland versus Blackhawk Manufacturing Corporation. And that was as recent as October 16th, 2023, where the court vacated the injunction that the Texas court placed upon the government ruling. And there was a prior case, Garland versus Vanderstock, which was narrow. It was a narrow 5-4 decision to vacate the lower court injunction on the federal guidelines. This is a court that has a negative view towards the administrative state. They're looking to overrule a doctrine known as Chevron deference, old case, 1984, I believe, Chevron versus Natural Resources Defense Council. And presently, the Supreme Court feels that there's too much power that the administrative state has. It's often been called our fourth branch of government. So it's going to become an issue, I think, down the line, whether or not the ruling by this executive agency, the Treasury, is valid, or is this an area that Congress should have weighed into and it should have been legislated. But for now, that's intact. There are two important cases, I think, interesting cases coming up dealing with the Second Amendment, and I believe it have a direct impact upon police officers' safety and just handling of gun-related calls. One is the issue over bump stocks. We're all familiar with bump stocks from 2017 Las Vegas shooting and from the hotel. And the case is Garland versus Cargill. And basically, it's whether or not the definition of a machine gun is defined under federal statute and by the ATF is going to cover bump stocks. For a decade prior to the Las Vegas shooting, the ATF took the position that it was not qualified as a machine gun. They changed their ruling subsequent to Las Vegas. So bump stocks are going to be challenged, and we're going to see a case before the court directly on that. The other issue is the United States versus Rahimi. And this involves whether or not a domestic violence defendant or an individual also convicted of a felony should be denied the right to possess a weapon. And it's going to be very interesting to see the outcome in this case, because Rahimi is somebody who was under domestic violence protective order, stay away order, and or convicted of the domestic violence, and had prior felony convictions or violent convictions, one involving a hit and run, and I believe also I have it in my notes here somewhere. Several other violent crime, multiple shootings. When the police searched his home, they found a rifle and a pistol. So he's making a Second Amendment claim that just because I'm a felon, you can't take my gun from me. It's going to be interesting to see how this turns out when it gets to the court and what the court might say. There's a case that Justice Coney Barrett, when she was in the Seventh Circuit, weighed in on, and it was Cantor versus Barr. And she wrote, founding era legislatures did not strip felons of the right to bear arms simply because of their status as felons. I mean, arguably, if somebody's convicted of, embezzling $3,000 and it's a felony and they get convicted, I can see the argument. Rahimi, we're dealing with somebody who has prior, multiple shootings, hit and run, based upon the facts that I read. So it's going to be interesting to see what the court decides in that case. Certainly, if they say, yeah, felons galore, have your guns, it's going to be a tough world for police. It's going to be a really tough world. I mean, we can all say, yeah, we value the Second Amendment, but we value a reasonable approach to the Second Amendment. I don't think it'd be reasonable to grant it in that sort of circumstance. We have a violent felon and requesting their Second Amendment rights. No right is absolute. Reasonable restrictions can be placed upon them, and that's what Justice Scalia even said in District of Columbia versus Heller, the federal case which preceded McDonald versus City of Chicago. But Scalia said, look, there's a Second Amendment right. It's an individual right. The court said that, as opposed to the court's old holding in Miller that it was a collective right. He said, but governments can still place reasonable restrictions upon that. And subsequently, the courts refused to grant review to cases challenging silencer bans and other bans, magazine capacity bans. So it's going to be very interesting to see how the court weighs in on this one. And this is all a result of its more recent decision in New York State Rifle and Pistol Association versus Bruin.
Yeah. And I mean, the devil's in the details, and
yes,
whether or not an embezzler has the right to a firearm, I don't know if anybody would really care that much. But that's why, going back to ghost guns, we're seeing the prevalence of ghost guns in the hands of convicted felons, gangbangers, easy to obtain, no serial numbers, no identifying marks. Use it, throw it off a bridge. If we were to say that regardless of your felony background, you could still you're entitled to possess a firearm, wow, that would be huge. And that's with the qualification that I am a believer in the Second Amendment. Don't get me wrong. I'm sure I'll get an email or two, but yeah, I mean, we've got to draw the line, I think, on violent, chronic, repeat felons and the access to firearms.
Sure, absolutely. And look, the watchword in the law is reasonableness. It's always the reasonable person standard. Myself and any of my colleagues in the Justice and Law Department at the university I teach at, the attorney faculty, were always drilling into their heads the reasonable person. So it's a question of reasonableness. And can the government place reasonable with a capital R restrictions? I don't think anybody has an argument with reasonable restrictions in keeping guns out of the hands of violent felons.
Yeah.
But you're right. Devil is in the details.
Absolutely. Hey, respectful of your time, thank you for being on the show. Terrence Dwyer, retired New York State Police trooper, investigator, professor, attorney, author, special. You've got it surrounded. You're going to release Homeland Security Law Issues and Analysis from Canella Publishing. You've got some articles coming out. Tell us a little bit about those.
Yeah, my new textbook. This is my third textbook. It comes out. It goes to press next week, and it should be out before the end of the year or just the beginning of the year. It's a textbook. It's guided towards graduate programs, but also law enforcement, federal, you name it, the issues involving Homeland Security issues, takes a look at the early stages of Homeland Security up through present times. Just again, law-based, very, very law-based. And then my upcoming article for my annual year-end review, which I've been doing for Police One since 2008 on the Supreme Court, what we talked about today. In the new year, I hope to get out some more articles dealing with qualified immunity, stop and frisk, the things that pertain to police officers that they need on the street. I feel in the academies they're given their training on weapons, defensive tactics, which is great, evac, driving, everything else. They get law, they don't get enough law. We need to arm them with the legal knowledge as well, not to be attorneys or practitioners, but to give them even more of the tools that they need out on the street, because that's important as well.
Yeah, absolutely. Hey, thanks so much for taking time with us today.
Thanks for having me. Take care.
All right. Hey, to our listeners, I hope you enjoyed today, and check out the article. I'm going to list a link in the show notes below, and look for Terry Dwyer's new book, Homeland Security Law Issues and Analysis, coming out soon. And hey, stay safe out there. Thanks for listening. Thanks for watching, and hope to talk to you again real soon. Take good care.